Hello, everyone. You're all very welcome to this week's Inspiring Ideas at Trinity's webinar. My name is Megan Donaldson, and I'm the Global Alumni Relations Officer here at Trinity Development and Alumni. This afternoon, we're delighted to welcome Oran Doyle, Professor in Law here at Trinity, and Arianna Vedaschi, Professor of Public Comparative Law at Bocconi University in Milan. They'll be discussing how different countries have responded legally to the current pandemic, particularly in terms of human rights, personal freedoms, and the rule of law in the midst of a global emergency. We also have my colleague Gareth Crowe joining us to facilitate the discussion and Q&A following the main talk. Before we start, I'd just like to run through a few things with you. If you're watching us on Zoom and you'd like to view this in full screen, you can do so by clicking the button in the top right-hand corner. If you need to adjust your audio settings, you can do so using the button in the bottom left. And if sadly, for any reason you need to leave the session, you can do so using the button in the bottom right-hand corner. We very much encourage you to ask questions, and you can do that by submitting them via the Q&A button there on the bottom of your screen. And our speakers will respond to these questions later in the webinar. For those of you who are joining us on YouTube, if you need to mute or unmute your video, you can do so using the small speaker button circled there in red. To share the webinar, click on the share link there on the right. And if you'd like to subscribe to our YouTube channel, you can click the red button, which does what it says on the tin, subscribes. We, of course, as I said, would love to hear from you. So please do share your thoughts and questions in the comment box, and these will be passed along to the speakers. This presentation should last around 35 minutes and will be followed by 10 to 15 minutes of Q&A. So we should take just under an hour and finish up around 5 p.m. Irish time. The webinar is being recorded for later viewing. If you're watching on Zoom, you'll get a link to the recording shortly following the webinar. And the recording will also be available via the TCD Alumni YouTube channel. Now, I'd like to introduce you to my colleague, Gareth Crowe, who will tell you a little bit about the Trinity Law School project and will introduce today's speakers. Gareth is an associate director here in Trinity Development and Alumni, where, among many other responsibilities, he works closely with the law school. So welcome, Gareth.
Thank you, Megan, and you're all very welcome, and thank you so much to you all for joining us this afternoon. Today's webinar forms part of a series of weekly webinars that Trinity Development and Alumni have been running since the regular daily lives for us all have changed so much. This series forms part of Inspiring Generations, the campaign for Trinity College Dublin, and allows us to reach out to you, our global community, at this time when communication and personal interaction are changed, but perhaps are now more important than ever. Today, we're going to look at how Trinity is responding to this crisis by mobilizing our scientific, research, engineering, mathematical, and other expertise. But today, we'll look at how Trinity is responding to this crisis in terms of the law and from a legal perspective. For many centuries, Trinity's law school has inspired lawyers and legislators who have challenged the status quo and changed the course of history, not just in Ireland, but globally. But to meet the demands of the centuries to come, Trinity is expanding its law school, enabling new curriculum developments and programs, and broadening its civic engagement. And all of this will be housed in a new building on campus soon to come. But that's enough from me. I'd like to introduce you to our speakers today. Today, we'll hear from Oran Doyle. Oran is a professor in law at Trinity College Dublin, where he was head of the school from 2014 to 2018, and is currently a visiting faculty member at the University of Pennsylvania Law School. He's an expert in Irish constitutional law and comparative constitutional law. Professor Doyle is the author of The Constitution of Ireland, a contextual analysis, and is currently involved in a number of research projects focusing on constitutional amendment and the constitutional control of territory. He's a regular contributor to public debates, and he was a constitutional law advisor to the Citizens' Assembly that reviewed the Eighth Amendment. And we're also so lucky to have with us Arianna Vedaschi, who is a full professor of public comparative law at Bocconi University in Milan. She was previously a visiting research professor here with us at Trinity, and also at Max Planck Institute for Comparative Public Law and International Law in Heidelberg. She is an expert on constitutional law, human rights law, emergency and national security law. She's also the coordinator of the research group on constitutional responses to terrorism within the International Association of Constitutional Law, and is a member of the scientific board of the recently established Comparative COVID Law website, which tracks legal responses to COVID-19 in countries on all continents. Thank you both for joining us.
Well, thanks, Gareth. Thanks for the generous and kind introduction. It's a pleasure to join you for this seminar today. I think the seminar has been phrased around personal freedom in a time of emergency, and I thought we could start by chatting about the circumstances or the meaning of the word emergency and why we talk about it. So in Irish history, we talk about the emergency. So the period of World War II was known as the emergency, and it was known as the emergency because a formal state of emergency was declared after World War II broke out. And Arianna Vedaschi, who is very shortly going to appear on the video, is an international expert on states of emergency. Her work began really in the context of terrorism and looking at emergency responses to terrorism. And I think she's going to, yes, now we have Arianna with us. We got over that minor technical glitch. So I thought, Arianna, you might be able to treat this sort of as a conversation between the two of us. There'll be a bit of back and forth rather than a formal academic presentation. But I thought you might be able to start off by talking a little bit about states of emergency, or why do lawyers talk in terms of emergency, and relating that to the COVID crisis.
Thank you. Thank you. Can you hear me?
Yep, everything working perfectly.
Okay, so first of all, I would like to say thank you to my colleague and friends Oran for inviting me to take part in this talk, as well as the TCD alumni office and all the people who worked at the organization of this event. It is a wonderful opportunity to, let me say, come back home in Trinity College again, even if on virtually. Here, I spent a great visiting semester in 2017, and I remember the lively atmosphere. I'm sure this webinar will be an interesting chance to share ideas and to live again the same vibe. So let's go to the legal responses to COVID-19. Well, taking a comparative law perspective and focusing on Western democratic countries, there are at least two constitutional emergency models. I mean, two constitutional frameworks dealing with emergencies. The first model, which dates back to the liberal tradition, can actually be defined as a non-model, since it is a silent model. It consists of those constitutions that do not explicitly regulate emergency. It is the case of Italy. Except for Article 78, addressing war in its traditional meaning, the Italian Constitution does not regulate other emergencies different from war, neither political nor non-political ones. That means no explicit nor specific regulation is provided for terrorist attacks, natural disasters, financial crisis, or epidemics, pandemic, and so on. Instead, other constitutions explicitly regulate emergencies. And this is the second model. This second model can be further divided into submodels. The first submodel is so-called general clause. The 1958 French Constitution is the main example, since this Article 16 gives the President of the Republic very vague and undefined emergency powers. Article 16 of the French Constitution can be triggered when the institutions of French Republic, the independence of the nation, and so on are under serious and immediate threat, and the proper functioning of the constitutional bodies is disrupted. So the Constitutional merely says that the President shall take measures required by these circumstances without detailing what the President can or cannot do. The second submodel is the rationalized model. I mean, those constitutions wherein emergencies are not just addressed, but also regulated in detail. The rationalized model can be again divided in two types. On the one hand, we have the growing intensity model, represented by the German Constitution as modified in 1968, where we have different constitutional provisions that regulate different degrees of risk stemming from a same source of the threat. On the other hand, we have the parallel levels model, exemplified by the 1978 Spanish Constitution. Here, different emergency clauses regulate emergency regimes deriving from different sources of dangers. Let me more specific. In Spain, we have the state of alarm, estado de alarma, the state of exception, estado de excepción, and the state of siege, estado de sitio, all provided by Article 116 of the Spain Constitution, which sets out procedures to resort to them. Then we have a law, an organic law, number 4, 1981, spell out the factual circumstances that justify the different declarations. Since that law establishes the state of alarm shall be triggered during epidemics in order to fight the COVID-19 emergency, the Spanish government, led by Pedro Sanchez, adopted a decree declaring the estado de alarma, the state of alarm, on all Spanish territory. The declaration of the estado de alarma implied significant limitations to rights and personal freedoms for 15 days. Yet the state of alarm has been extended several times on the required authorizations of the Spanish Congress. Well, among the countries that I have examined, Spain is the only one to have applied its constitutional emergency framework. As a matter of fact, France did not trigger Article 16 of the Constitution, which is considered as a clause to manage political distress. France entered the current health crisis at a first stage resorting to the Code of Public Health, which gives special emergency powers to the Minister of Health. Then an ad hoc law setting up a new regime called État d'urgence sanitaire was rushed through the French parliament and entered into force at the end of March. Also, Germany did not trigger its constitutional emergency clauses, but it relied on a federal law called the Protection Against Infection Act 2000, then amended in 2020 to face the coronavirus crisis. So actually, open our view to countries outside the EU, the European Union, you can see that other countries have decided to pass a new law to deal with the COVID-19. In the United Kingdom, for example, an ad hoc emergency law, the Coronavirus Act 2020, was adopted by the Houses of Parliament. As we know, the first reaction to the epidemic was very skeptical, since Prime Minister Boris Johnson even invoked the so-called earned immunity. But this approach radically changed in a few weeks, and strict lockdown measures were taken, and even a new act was passed. So, therefore, at the first stage, we can see a different timing in Western democratic countries' reactions to COVID-19. But after some weeks, we can see a substantive alignment of the measures taken. Strong limitations of personal freedoms up to full lockdown have been applied by all Western democratic countries. And this approach, I think, is based on the Italian paradigm, initially ignored, then criticized, but eventually emulated by other jurisdictions. This is a comparative overview, of course, only on focusing on democratic Western countries.
Thanks, Arianna. I think that's really helpful, and we're both comparative constitutional lawyers, and it's these comparisons that tell us more about what's going on in our own country, and we can understand it better. And I think that framework of emergencies provides us with some insight into what's going on in Ireland. So I was mentioning at the start, so we refer to World War II as the emergency because we declared an emergency. It allows the state to sort of step outside the normal constitutional protections to operate in a different way. But like Italy, there's no power to declare an emergency other than to do with war, armed conflict, or armed rebellion. So Ireland has really had to frame its response to COVID-19 within the existing legal rules and standards that apply, which are obviously sensitive to the pressing public health concerns. So I think we see there was a challenge in Ireland by two journalists, might be an overly charitable word for them, to the constitutionality of the legislation. It's unsurprising that that challenge failed, but constitutional concerns around Ireland's response to COVID have clearly helped shape and frame that, and it is possible at some point that somebody might bring a successful case challenging some aspect. I'm not predicting that, but it's there as a possibility. A couple of other constitutional factors, I think, have really driven the response in Ireland. And we had a general election, as viewers know, at the start of February, and still no government has been elected after that general election. So we've had what people colloquially refer to as a caretaker government. It's a government that has less political authority because it's lost its mandate, and also there's certain constitutional tasks that it can't perform. The Prime Minister cannot appoint any new ministers, for example. Even more oddly, perhaps, a knock-on effect of this has been that the Senate hasn't come fully into existence. So we also don't have a full legislature, and that means that no legislation can be passed, primary legislation, statutes, to deal with the COVID emergency. I think these factors are shaping the response in two ways. So I think at a technical legal level, they shape it in that the Parliament, through agreement between the various political parties, agreed new legislation in March that gives authority to the Minister for Health primarily to make regulations to protect us against COVID-19. And the laws that we have are really the laws that the Minister for Health has been making and updating periodically. So as the lockdown restrictions ease, amendments are made to those laws. But I think there's a sort of a deeper level that's becoming clear to me, that this sort of constitutional situation is shaping Ireland's response, because I think that the government, having lost its democratic mandate, in some way had less democratic authority and came to rely quite heavily on the expert authority that the public health doctors and the public health experts have, in particular in Ireland, the National Public Health Emergency Team, which issues recommendations to the government. And of course, the government then decides in principle whether to accept those recommendations, whether to make new laws. But I think it's becoming clear, particularly now as there's pressure to ease the lockdown, that I think the government finds it very, very difficult not to follow the advice that has been given by the experts. You might think that is a good thing, you might think that is a bad thing, depending on how you weigh up expertise versus political control and democratic control. But it seems to me that the government became so reliant on expert authority in justifying the lockdown that when the experts, Ireland, as well, the context for this, Arianna, is that Ireland is seen as, rightly or wrongly, moving more slowly out of lockdown than some other countries. I'm not an expert, so I don't know what the right approach is. But anytime there's political pressure to go a bit faster, there tends to be a bit of pushback from the experts to say not so fast, and that seems to be the end of it. And I suspect if we do get a government elected in the next few weeks, which is possible, we may see a bit more of political pushback against the expert advice. So those are just dynamics to observe and to emphasize. I'm not saying they're appropriate or inappropriate. So those are a few things that have specifically stood out to me about Ireland's response. In terms of Italy specifically, you're obviously an expert on Italian law as well as on comparative constitutional law. Are there any features of the Italian experience that you think are particularly interesting or important to us?
Well, just focusing on Italy, as I have already said, the Italian Constitution does not provide any explicit constitutional framework governing emergencies different from war. So I can call the Italian model a silent model, but I would like to say it's not a mute model. Why? Because our Article 77 of Italian Constitution states that in extraordinary circumstances, for example, to address a natural disaster, the government can adopt its own decrees, having the force of law. That kind of decrees are called decree laws, and they are temporary. So if they are not converted into a law by the Houses of Parliament within 60 days of their publication, of the publication in the official journal of the Italian Republic, they lose their effects from the time of their adoption, as if they had never existed. Well, after declaring a national health emergency, the Council of Ministers, I mean the Italian government, managed the COVID-19 crisis through a set of decree laws. Nevertheless, these decree laws deferred the adoption of specific measures limiting personal freedom strongly to decrees of the sole president of the Council of Ministers. I mean, of decrees adopted by our premier, our head of government, head of executive. And this is a tricky issue, as these measures strongly impact on rights and freedoms, such personal freedoms, that according to our constitution can only be limited by laws. Yet, decrees adopted by the President of Council of Ministers do not carry the same guarantees as a law or a decree do. First, they do not have the same legal force as law, nor are they converted into a law. Second, they are not issued by the President of the Republic, who instead issues decree laws and acts. And when the President of the Republic issues decree, is check their compliance with the Constitution. Instead, decree adopted by the sole president of the Council of Ministers are not subject to this check. Third, not having the force of the law, they cannot be challenged before the Constitutional Court, as the Italian Constitutional Court only rules on the constitutionality of laws and acts having the same legal force of the law. So let me express a couple of remarks on the Italian response to coronavirus. First, strong limitation of rights and freedoms are taken by secondary sources, whereas our constitution prescribes that many of these rights and freedoms can only be limited by primary sources. Second, the adoption of all these measures saw a key role of the head of the executive, and at the same time, a clear marginalization of the Italian parliament. I know that a pivotal role of the executive is quite a natural feature on any emergency. However, in this case, it is even more worrying as the head of government, as indeed the real master of the situation, rather than the whole government, all Council of Ministers, and parliamentary checks over his activity were almost lacking. Then, if I have just a couple of minutes, I would like to highlight and emphasize another tricky issue. I know that you know that Italy is a regional system. So Italy is a regional state made up of several levels of government, central, regional, and local. Not always the sub-central levels took measures that were completely coherent with the national ones. And this approach created inequalities on the territories, as well as problems of certainty of law. Maybe if we have time, we can come back to this point during our discussion. Please, Oran.
Yep, thank you. I think that's very helpful, and we see that reflects some of the issues that have arisen in Ireland as well. So because these regulations are all being made by the Minister for Health, there's less there's no parliamentary scrutiny really of them. They can be overturned by Parliament, but it's really not perhaps as much democratic involvement as you might like in the making of the rules. I think for me, then it sort of prompts that, thought that there's three issues that are sort of striking or standing out for me about the way in which Ireland is managing the lockdown restrictions. And one sort of was really brought home to me by the travails of Mr. Dominic Cummings in the United Kingdom, which news of which may have spread as far as Italy, if you're unfortunate enough. And his issues about whether he was able to leave his home and travel to Durham. And the same sort of issues arises in Ireland because our regulations are rather similar. So the primary function of the primary way in which the regulations work for the lockdown is to say that effectively that it's a criminal offence to leave your dwelling unless you have a reasonable excuse. And then the regulations set out a number of very precise legal reasonable excuses that people who are living in Ireland would be very familiar with, so that you may leave to go shopping if you're an essential worker, or leave to take exercise within 5 kilometers of your house. There's a number of very specific ones, but there's this overarching category of just reasonable excuse in general. And that's what Mr. Cummings was trying to rely on in the UK. And that would similarly apply in Ireland. So leaving your house is not limited to the specified reasonable excuses. It's this general category of reasonable excuse. The difficulty with that, of course, is that it can be hard to know what would count as a reasonable excuse. So on the one hand, it builds in some good flexibility. Perhaps there's been talk of people trying to flee from domestic violence, which is not listed as a reasonable excuse, but I think we would see that as a reasonable excuse to have left your dwelling. But on the other hand, it means that if you're trying to live your life as a law-abiding citizen, it can be quite difficult to know what you're allowed to do and what you're not allowed to do. And that's an issue, particularly in Ireland, more so than it would have been in the UK, because in Ireland, we have a written constitution, like Italy, and one of the constitutional principles is that criminal laws cannot be vague. And there's a case from around 10 years ago in which the court struck down a law that required non-nationals to produce their passport unless they had a satisfactory explanation for a failure to do so. And the court said, satisfactory explanation, that's just too unclear. How could you know in advance what that means? And they struck down that law. Now, reasonable excuse is a bit better than that. Okay, so I think reasonable excuse is more objective than satisfactory explanation, but there's still a bit of lack of clarity on this, and I'm certainly not going as far as to say that the legislation is unconstitutional, but I think these are the sorts of issues that arise. Okay, so there may be some doubts around its constitutionality for that reason. I think the second big feature that stands out for me of Ireland's response of managing the lockdown is a sort of blurring of what's legally required and what's just advice and guidance. And I think the government, it seems to me, is being quite happy to allow this blurring go on. So one of the measures that has been brought in, or sort of one aspect of advice, was that over 70s, people over the age of 70, to use an expression that's somewhat patronizing, be cocooned in their homes, just couldn't leave their homes for any reason. But that was never the law. That was always just advice. The law has never set any different restrictions on people based on how old they are. But I suspect that quite a few over 70s people in the country believe that they were legally prevented from going outside. And I think it raises rule of law concerns. It's obviously done for very good reasons, in order to protect public health, in particular the health of vulnerable people. But I think something is lost for a society if we're willing to blur the distinction between what you're legally required to do and what the government is advising you to do. And I think the final issue, just to touch on very briefly, so you've mentioned this problem of multi-level governance within Italy of different regions and taking different approaches that may contradict approaches higher up or lower down. We don't have that in Ireland. It's a very simple unitary state. But what we do have is Northern Ireland and complete freedom of travel between Northern Ireland and Ireland. And I think at the outset of the crisis, when the UK was taking a divergent approach, this became a source of stress in relations, both relationships within Northern Ireland and also between North and South. And I think as we move into easing the restriction phase, where it looks like the UK wants to move quite a bit faster than Ireland wants to move, that's going to create a lot of difficult questions that we're going to have to grapple with. So those are really my thoughts about Ireland. Maybe just sort of hand over back to you, Arianna, for some concluding observations before we move on to the Q&A. But are there any sort of broader lessons, or going back to that broader perspective, some points do you think that we should be trying to think about or learn about or consider in more depth?
Yeah, I think that from a comparative perspective, the COVID-19 pandemic is a real challenge for all constitutional systems, both those which have an emergency framework and those which have not. In the former case, with the only exception of Spain, other countries with a constitutional emergency framework did not resort to it. Indeed, we can highlight a sort of escape from settled emergency rule to the point of amending existing emergency acts or even passing new ones. For instance, France decided to come up with a new emergency framework, enshrining a new law. The same we can see in the UK. Germany amended its federal legislation on a health emergency. And what about Italy? Well, as I have said, COVID-19 shed light on several issues that you mentioned also now, some of them connecting to the lack of an emergency constitution. So this problem with different levels of government. So I think that when the current emergency is over, it will be time to open a debate on the regulation of emergency in the Italian constitution. The choice in favor of a silent model could be understood after the terrible experience of the Second World War in the fascism regime. In that historical moment, I think it was more than justified. Yet now, after decades of hybrid wars, terrorist attacks, and even pandemic, it might be necessary to question and to revise that choice. I think that this is a great opportunity to revise our constitution from this specific perspective. And I think also that for your country, it could be an opportunity to face to problem and to deal with this new issue. What do you think?
Yeah, I think that's definitely something we're going to need to consider. Our constitution can be difficult to amend. It can only be amended by way of referendums, so that is doable, but it takes quite a job of persuasion, I think, to explain something that's sort of quite technical about the way in which the state works, and to be able to explain that to citizens is a reason why they should support the change. So I think it's doable, but it takes a bit more work, as distinct from issues we've had so recently, which are more sort of personal, social, moral issues around marriage equality and abortion, where whatever view you take on those issues, the importance of the issues and the change that was being considered could be made relatively clear to people. But yeah, I think there's a lot of things that we can take out of this. Just before handing over to Gareth for the question and answer, one of the things we're doing in Trinity to grapple with this is that we've just established and going live today, really a law and human rights, COVID-19 law and human rights observatory. So a lot of my colleagues from the School of Law and from other disciplines and also from beyond Trinity are working together to provide an analysis of how Ireland has been responding to COVID-19 in the hope that we can draw those lessons for the future. And I think that's hopefully going to be an important contribution to public debate. So look, I've really enjoyed the chat so far, but let's hand over to Gareth and see are there any questions been coming through that we could respond to.
Thank you both very much for that very interesting conversation. And yes, there's plenty of questions going through thick and fast, so that people have lots of things they want to ask you. So I suppose I'll touch on one that I think pivots very nicely from what you just ended on there. So just Ursula would like to know, just in terms of the right to protest during the crisis particularly, which has become obviously a very live issue with recent protests in Dublin over the last weekend, in fact, and the Minister for Health here stepping in to call for coming protests to be cancelled. What counts as a proportionate and necessary interference of that particular right, especially if protesters are adhering to social distancing, travel limits, masks, etc.?
Do you want to have a go at that one first, Arianna?
No, please, please.
Yeah, so I think this, so this raises a question. So I think going out to protest is not covered by one of the reasonable excuses. So the first question that then you'd have to ask as a lawyer is it a reasonable excuse to go out to protest? In that context, the right to protest is protected under our constitution, but it's subject to public order, public morality concerns. And that's, it's a really difficult question to ask where those lines should be drawn. I think the state, my view is that if the state were to prohibit protests, for a period of time, it would probably be able to defend those prohibitions in court. I think a court would be slow at the moment to step in and say that the state was wrong to do so. It's probably, it might be a better response to try to control how the protests, as you were saying, that all physical distancing and so on is respected during protests. We know that scientists tell us that the risk of spreading the virus is much less outside than it is inside. At the same time, protests are inherently difficult things to control. And it maybe just comes down to a sense where really, like lawyers, sometimes we might pretend that we have better answers, but I'm not sure that we do. But how do you balance these competing concerns? On the one hand, we all want to reduce the spread of COVID-19 as much as possible. On the other hand, we recognize the importance of protest and as a way for democratic change and peaceful change. And where do you draw the line between those two is just hugely difficult. So I think I'm not precisely sure where I think it should be drawn. My own view is some level of protesting should be allowed, but it's very difficult to control it. But I think the state would be able to take a reasonably strict view if it wanted to. But maybe Arianna has having seen how other countries have dealt with it, may have some other thoughts to suggest.
Well, in Italy, at least the first stage, the right to protest has been restricted for the health reason. So our government, in the balancing of our government, the health was most important than other personal freedoms. But for example, now at the second stage, it's possible to exercise the right of protest, but not dynamic. I mean, static with the caution that Oran, you just mentioned. If I can put it, on the table a comparative view, I would like to say that in Spain and in Germany, that kind of problems are in front of the court of judges. And in Spain, we can see a different approach. taken by administrative court and even by the constitutional judges. They prefer in that moment to protect the health issue, and then say, okay, we can tolerate some restrictions, some limitations on other rights, assembly, and also the protest right. In Germany, we can see a different approach. In the first moment, just to give you a rough idea, at the beginning of April, the administrative judges was quite different in front of the political decision to stop, to block some kind of assembly. And even the Constitutional Federal Tribunal. But in the second part of April, the approach taken by the Constitutional Tribunal has changed. So is more similar to your position, and that is my position, Oran. So we have to balance other rights, assembly, protest, and so on, and health. And so we can put some rules, some limitation, and so we can express our thought, but with some social distancing, with all of the stuff that we already know.
Thank you. Just in the Irish context, and Oran, maybe this might be something that you would maybe address, but do we need to wait, or do we have to wait for a newly elected government in order to challenge the constitutionality of the Irish lockdown? Or how soon could it be challenged in your view?
Yeah, okay, well, first of all, I just want to, if there's a premise in the question that it should be challenged, I'm not accepting the premise, okay? But there's no legal, there already has been a challenge to the constitutionality of the lockdown. It failed because it was thoroughly misconceived and yeah, it was just misplaced. I think the only, I think a challenge could arise, but I think it's if one comes, it's going to come in a very concrete case, and it's somebody who's going to point to something very specific that has happened to them, that they've been, and probably in the context of somebody being prosecuted for breaching the restrictions, I think. So it's not going to be some sort of, there are obviously people who think we've taken the wrong policy approach, and there's plenty of room for disagreement about that, and people can lobby their politicians and encourage different laws and so on. But there's not going to be any successful challenge on that basis, I think. But there may be a successful challenge where somebody's been prosecuted and they can point whether it's to vagueness in the law, or that really it was disproportionate, or like perhaps, okay, a protest has been prohibited and they want to say that it was a disproportionate interference with their right to freedom of assembly. But those sorts of challenges take a while to unfold because they depend on evolving sort of fact situations. So no reason why a challenge couldn't be taken now, but I think a challenge is going to depend on something particular happening, and that just naturally takes a bit of time to evolve.
If I can't add a word, if we go back for a minute to the Spanish experience, it's quite paradoxically that Spain's choice to declare a stato di allarma, state of alarm, was criticized by Spanish scholars, not just by the political opposition, but by many Spanish scholars, because they underline that this kind of regime does not allow suspension of rights. For example, the right to protest. The suspension of rights is not allowed under the state of alarm. So these scholars claim that if the government wanted to suspend rights, to stop, for example, manifestations and so on, it should have resorted to the state of exception, so a different regime. But the law that I've mentioned before, number 4, 1981, doesn't list the epidemic among the emergency circumstances that allows the state of exception. So we have consequences that are coherent with a declaration that is not coherent with the circumstances, I mean the factual circumstances listed in an ad hoc law. For that reason, I think that even in Spain or in Germany, that they have emergency regime, maybe we have to rethink our emergency framework. Constitutional, I know, Oran, is difficult. Even in Italy is very difficult because we have a very heavy procedures to modify, to amend our constitution. But I think it's necessary because, you know, is during the stress time that we can see if we are a democracy or we are something different.
Thank you. Actually, I think the next question is a perfect segue from what you just said. And Linda's asking us, taking a comparative perspective, what are both of your views on the cumulative impact that these you started your talk talking about emergency, that these emergency situations will have on the protection of human rights globally, in your views?
So I'm happy to have a first go at that, and then see Arianna can come in on it. I think what we're definitely seeing is countries that already had a bad approach to human rights, to democratic safeguards, seem to have taken advantage of this crisis to accelerate their setting aside of human rights standards. So within Europe, Hungary is the most obvious example. Hungary is pretty close to being an autocratic regime at this point, and Viktor Orbán just, I think, took advantage of the crisis to go where he was already going and to get there a bit faster. Beyond that, my sense is that it's a little bit too early to tell. So obviously our human rights are being restricted in Ireland at the moment for good reason. Okay, and maybe there's quibbles around the edges, but I think nearly everybody would accept that we have to restrict personal freedom at this time. But what's going to happen when we come out of that? Are we going to say, well, that's whether formally an emergency or not, but that was an interruption on the blip and we go back to where we were before? Maybe. Or perhaps the government gets used to having this sort of power and therefore wants it more often, in which case human rights will be more damaged. Or maybe, possibly, this is going to refocus attention on other sorts of human rights and the sort of vulnerable groups in society who've been affected particularly badly by the epidemic or by the crisis. And maybe it's going to cause us to take more concern for those human rights in the future. I'm not sure how optimistic or pessimistic I am on that, but I think it's maybe just a little bit too soon to tell for some countries, but definitely in other countries, the trajectory is a bad one.
I completely agree with Oran about what Oran said on Eastern Europe, and we can also think the same about Asia or other countries that they do not have a liberal tradition. And I would like to add another problem about our countries, the countries that we can say they have a liberal tradition and they are democracy, mature or not mature, but they are democracy. I think that COVID-19 emergency show another problem about the centralization. For example, in some countries, not just Spain, but even Italy and so on, we can see an excess of centralization of measures, disregarding powers and factual circumstances of single regions and single territorial area. And this is a problem, especially in Spain, where the constitution gives that kind of power to the regions, to the comunidades autónomas. Maybe the best is Germany, because of course lenders have competence in that area, in the health area, but the federation did well with the way of the agreements, a political agreement between the federation, the central level, and the regional level. So maybe that problem of the centralization is less evident in Germany, is more evident in Spain and in Italy, but could be another problem about rights, about good exercise of power, because if you re-centralize the decision, that means less democracy if you look at the dynamic of state system.
We probably have a minute or two left, but we don't have enough time for any other questions at this point. Is there any other comment from either of you you'd like to just touch on that particular one, or anything else you'd like to say at this point? We probably have 1 minute, 30 seconds left or so before we wrap up.
I think we're just seeing, so one observation that academics have been doing research on is that traditionally the notion of an emergency involved a very strong government having almost dictatorial powers, typically during a time of war, to step outside usual legal constraints and do what was necessary to protect the country. But I think research that's ongoing into how countries are responding is that that's not really what is happening. That there is much more collaboration between government and parliament, perhaps not as much as we would want, but more than you might have in this old style notion of an emergency. And maybe that's where more thinking and work needs to be done in terms of this type of emergency. How do you manage it? How do you get people to work together? And that might be in a more democratic and inclusive way than would have applied before when, say, a country was threatened with war.
Yeah, I think that this emergency could be an opportunity. Paradoxically, it's a tragedy, I know, but it could be an opportunity to see what it didn't work and to make some amendment. So I agree with Oran, and I think that now we are in a good space to a new start, in a good point for a new start.
Okay, thank you both. But just and also to thank everybody who submitted questions. Unfortunately, we weren't able to get to them all. Time, as always, is a great enemy. But thank you all for your attendance. I'm going to hand over again to my colleague, Megan Donaldson. Thank you all.
Well, thank you everybody for such a fantastic talk that we've had this afternoon. It's been really, really interesting. And I'm not a law expert, but I have learned an enormous amount this afternoon. So thank you everybody. And before we go, I'd just like to say a huge thank you to Oran and Arianna for joining us from Oran's in the US at the moment, and Arianna is in Italy. Just treating us to a really thought-provoking, interesting webinar. We'll all go away with a lot to think about. I'd also like to thank all of my colleagues and the team here at Trinity Development and Alumni who have put in an enormous amount of work in making these webinars possible. And last but certainly not least, I'd like to thank all of you for joining us today and for your enthusiastic engagement and sending in your questions and comments. We had about 200 people listening in today, so thank you for being such a great audience. If you enjoyed today's webinar and would like some more information on these topics, we've shared a few websites there on the screen for you. If you'd like to learn more about or support the Trinity Law School project, please visit the link on your screen, or you can go to www.tcd.ie/campaign, click on projects, and then scroll down for the link to the Trinity Law School. Two additional websites that might be of interest are the newly established COVID-19 Law and Human Rights Observatory, which you heard Oran mention earlier, which sees the Trinity Centre for Constitutional Governance joining forces with the Corporate Law, Governance and Capital Markets Research Group to engage in research across the full range of Ireland's legal response to COVID-19, with the aim both to inform the public and to provoke public debate. There's also the comparative COVID law website, which tracks legal responses to COVID-19 in countries on all continents. And finally, if you have any questions or comments regarding this webinar series or any of the work done by the Trinity Development and Alumni Office, please email us at alumni@tcd.ie. Our next webinar in the Inspiring Ideas at Trinity series will be this coming Wednesday, the 10th of June. Linda Hogan, Professor of Ecumenics here at Trinity, will speak on the ethical response to COVID-19, who decides and why it matters. The registration link will be sent around by email later this week, so do keep an eye on your inboxes. We do hope to welcome you next week, and in the meantime, thank you once again for joining us, and stay safe.